Next, I will mention item not T2 Malak, upgraded my petition in custody. Malak.
Is in custody?
Oh, yes, Malak, that's 2 Malak. Last item, Malak.
Okay, we'll try to take up.
I love it.
Item 32. Yes.
Lordship, item 22. Lordship, I am appearing on behalf of I Hussein Lordship. Lordship, actually, he's on leave, Lordship. And I seek an adjournment.
Okay. Item 22.
Yes,
22.
yes.
Okay. Both sides are represented. List after 2 weeks has paid for by and cost of the petition. Okay.
That resolution.
Yes.
Item number 24, Malak.
24.
Yes. Only adjourn for 2 weeks, Malak. And
2 weeks, 24.
leave it.
May I please, Your Lordship? Lordship, I beg to mention item number 7, Your Lordship. Lordship, kindly adjourn the matter for a week, Your Lordship.
2 weeks. Item 7.
Highly obliged.
7.
May I please, Lordship? I beg to mention item number 15, Lordship. Lordship, may kindly adjourn this matter for today and list it on next week, Lordship.
Still, item 15.
15, no?
15, one thing.
May I please, Lordship? I beg to mention item number 9 for adjournment. Kindly, item number 9.
9.
9.
Okay, 2 weeks.
Okay.
Item 1 or motion.
You want to read it, please, my lord? 22, my lord.
Okay. Ms. Verma, you were supposed to tell us where the records are.
Lordship, if possible, Lordship may kindly fix it at 2, Lordship.
At 2. Okay.
Yes,
At 2, my lord,
This
I
was-
will not be. At 2, my lord, I
No,
will-
we only need this information because where is this?
Yes.
Where is this?
I may not be there here, my lord.
29 July.
Ask somebody to be here.
Yes.
Okay. This is opinion dated 7/10/2002
Yes, Lordship.
by the legal IMDT
IMDT.
Gwalpara.
Golpada, yes.
Yes. You need this for the numbers.
No, not necessarily yet.
You have it.
W-
Yes, I have energy. Yes.
Okay.
At 2, my lord.
Ask somebody to be here.
Yes.
Item 2.
It will be instructed.
May I seek petition? In this case, my lord, some reports is called for from the Coroner Tribunal, Gabriel. Lordship may say
Karbi Anglong.
order dated 19/4/2021.
You have seen this? You are required to tell us.
Lord.
Just see this order.
It will auto yet acid.
Hmm?
Stated to be. Instruction as well. Acid. Has been disposed of or not. It will already nice.
এই যে জোয়া হেরি থাকি জোয়া 6 তারিখে থাকি
6 তারিখে আহিছে
আমি তো এই আজি দেখি
মানে আমি পঠিয়াইছো কিন্তু আমাৰ ফলো আপ হোৱা নাই লৰ্ডশিপ at 2 lordship we have already communicated we should get the instructions.
Lordship, this matter may be fixed day after tomorrow or Monday, Lordship.
Then Monday.
Monday.
Day after tomorrow is
Yes, Sunday,
you may not be
Lordship.
there.
20
But we need your undertaking that you will be here. Okay,
Wednesday would be better lordship.
better. Okay.
Yes.
6 তারিখ আজকে
Both sides are represented.
20
List on 27/11/2024.
মানে it might 28 month
28 is hearing day.
20
We make it 29 then. List on 29/11/2024 so as to enable the learned standing council for the FT matters to get the information in terms of the earlier order.
Order dated 19/4/2021.
19,
4/2021.
19, 4/2021.
2021 lordship.
Okay.
One second.
I love this.
29, 11,
Item 3,
to DDIT petition.
Madam, this writ petition has been filed challenging the second proceeding after declaration of the petitioner as a foreigner, and the earlier proceeding was challenged before this honorable court. Pending the earlier proceeding, writ petition, the second notice is issued, madam. That was challenged, madam. Page number 75 was the earlier opinion.
We will take both the matters together.
Yes, lordship.
My lord, that matter is already heard and it is fixed for judgment.
But then we adjourn this matter, awaiting
Obliged.
further orders on that.
Obliged.
Okay. What is the number of the writ petition?
1864, that is
1864.
of 2020.
Okay.
Who fits here, sir?
Mr.
Element of
Court number 3.
3.
M.J. Kadir, learned counsel for the petitioner, submits that
2020.
the petitioner has challenged the earlier opinion of the Foreigners Tribunal by filing WPC 1864 of 2020, which has been heard and reserved for orders. Full stop. It is submitted that this, by filing this writ petition, the
Subsequent notice, my lord, page number 84.
petitioner has been served with a notice. You have served with a notice
Yes, 84.
for appearance in another proceeding before the Foreigners Tribunal, Tejpur First, Sonitpur, in FT case number 83 of 2017, which is challenged in this writ petition. Next paragraph. Awaiting the verdict in WBC 1864 of 2020, this matter stands adjourned today. List after 2 weeks on a date to be fixed by the registry.
Obliged. Your lordship may post it after the ensuing vacation also, madam, because they maybe take time.
No, let us see. We don't know. Let us see.
But the lordship petitioner has participated in both the proceedings.
That's why.
We will
Yes,
wait for that.
in the second case, the opinion is not rendered.
No.
So he's just participated.
Yes,
He
lordship.
appeared and
She has
then
appeared, lordship.
and filed
She's filed
Yes.
a WS.
the petition here.
Yes, madam. Obliged.
item 4,
In item Miller 4, 5, and 6, I am for the petitioners, and what happened, Miller? He Begum also appearing with me, and she has taken the file yesterday to she will appear, but morning informed that her daughter is going to exam.
Pardon me?
He Begum will appear in this case, Miller. He will submit before lordship, but
In adjournment.
Okay.
lordship.
adjournment. Either Miller 2 p.m. or Monday or any other day.
Can we fix it on Wednesday?
My lord.
Because there will be some logistic problem for listing it on Monday today.
Anyway,
Some-
we have no.
Okay. on the,
As per your
Clear.
lordship,
both sides are represented on the prayer made by learned counsel for the petitioner, list on 27/11/2024. All three matters. Item 4, 5, and 6.
my. First,
Item 8.
Laws of Mission.
Yes, this is item 8. No one is there. No representation from the petitioner for ensured justice. The matter stands adjourned today. Please after a week.
Item 10. Item 10.
Please, your lordship. In this case, the present petitioner is inside at present. And
What is the date of opinion?
29/3/2023, lordship.
2000?
Opinion is 29/3/2023. Opinion is at page 73.
You filed a review also.
IA, your lordship.
No, review was fine, no?
What is the IA for?
The FT, Dukhi, it will know, Dukhi Mia.
Review petition was filed, your
What is
lordship.
the IA for?
IA for bail, your lordship. Is in that detention camp, your lordship.
It's taken into custody.
Your lordship. And review petition was filed for correction of the order or considered the case submitting some new documents.
Give a bill to him.
He's six, old age.
He's not because of the old age, but because of the name.
Your lordship. Actually,
He was arrested only a month back, Lordship.
My lord,
Opinion, Lordship, the references of 17 opinion passed in 23, but
No, we
arrested
see-
only last month, and that too after Lordship pulled up the Home Department.
No, we understand, but
his name
because
reclaimed,
of
my
the
lord.
name,
When I took the case,
it
he,
becomes indictment.
the, his relatives told he is actually beggars.
No,
Yes.
no, these people are, they take it for granted that nothing would happen.
3 times, lordship shifting was there. So due to erosion by the river Brahmaputra, basically they are
Lordship
from
may call
belonging
for
to
the
Chor area.
records, Lordship.
Yes, yes, we'll call it.
Yes.
We'll call it.
Notice has not been issued also.
Yes,
Notice
we understand. What is the date of your arrest?
Your lordship, date of arrest is 7/8/2024.
7/8,
My lord.
3 months almost. Okay.
I don't think so. We need-
In repetition. But Mr. M.U. Ahmed, learned counsel for the petitioner. Yes. A. Verma, and standing counsel for the FT matters in Home Affairs, representing respondent numbers 2 and 6. Mr. H. Kohli, Lanet.
Lordship, even 4 in the IA, Lordship, I would be
No,
representing.
yeah, I'm in the rate petition. In the rate petition, number 4 is Election Commission.
Oh,
Right.
he's changed it in the IA then.
Oh, then you'll be in difficulty.
Yes,
You'll have to correct it.
My lord.
because IA, the election commission is not there, Lordship. Not matching with the repetitions.
My lord, I may allow to correct you, lordship. It is not matching.
For the bail, perhaps he is not required, so he is given the cost title at page 4. Election Commission is there. In this IA, he is not a necessary party. I think that's why he has.
And no, even he's added jailer transit camp in the IA, Lordship.
That is wrong.
I may allow to correct you, lordship.
Okay, do it. You see, both sides are represented. Mr. M.U. Ahmed, learned counsel for the petitioner, applicant in IA 3033 of 2024 submits that there is an inadvertent error in hearing of the parties in the cost title. Praise for allowing me to correct it. First of prayer is allowed. The amended cost title shall be submitted before the AOJ. AOJ FT unit. First on receipt of the same will be incorporated in the interrogatory application and thereafter listed again. You do it.
Fine.
File a type copy as per the new rules.
My lord.
Item 11.
In this case, lordship. At the
1-year-old opinion. What is the reason for not coming on time?
my lord.
What is the explanation for coming after a year?
My lord, explanation has given at is lordship. At page 22, your lordship. Some due to miscommunication between the engaged counsel and the petitioner, your lordship. Some delay was there to deliver the judgment by the engaged counsel to the present proceeding, lordship. At page
But you know, there is a
23, lordship, I have stated. Page 20, paragraph 23, lord.
you know, when you go to some movies, you find some storyline very interesting. At times when you go to another movie, you find that the storyline is horrible. You have that experience of going to movies, no? You see, come to page 77. You obtained the certified copy in 18/11/23.
For the date of judgment, your lordship.
No, whatever will be the date of opinion. On 18/11, you obtained the copy.
My lord.
After that, what is the story? That's why if you don't have time for other matters, go to some movies every day. You will learn how to perfect the art of storytelling.
Judgment 17/10/2023, lordship.
Don't make those decisions. This will become a false statement. And again, because of you, the petitioner will again be in trouble. Heard Mr. M.U. Ahmed and counsel for the petitioner. Ms. A. Verma, and standing counsel for the also heard Ms. A. Verma and standing counsel for the FT matters in home affairs, representing respondent number 2 and 6. Ms. P. Barwal and standing counsel for the respondent number 4, and Mr. P. Sharma, Leonard, additional senior government advocate appearing for respondent number 5. There is no representation from respondent number 1 and 3. Next paragraph. By filing this writ petition, the petitioner has sailed the opinion dated 17/10/2023, asked by the learned. Opinion is page 77. Opinion dated 17/10/22, passed by so and so in so and so, comma, by which the petitioner was declared to be a foreigner of post 25/3/1971 stream. Notice extra copies within 2 days. Call for the records. Petitioner shall appear before the Superintendent of Police, Border, Borpeta,
My lord.
within 10 days and furnish bail bond of rupees 5,000 with one surety of like amount of this satisfaction of the said authority. On those conditions, petitioner does not appear, the order of bail should stand lapsed by effects of time. 10 days time to take bail.
Obliged.
Lordship, pardon me, my lord. Lordship, item 8, my lord. I was in another court, my lord.
Item 8. Just wait for some time. Let me
Right,
finish this.
right.
and we'll follow up again.
Item 12.
Yeah, please, your lordship. Lordship,
How's the health of Mr. Bhuya?
he's bed rest. He's under bed rest. He's not able to read.
Where is the opinion?
My lord, page 84.
84. Have you filed a complaint against the lawyer? No.
There was a miscommunication between. in this
Lordship
council.
will come to 86, Lordship, where it's explained the member has put on record why the wakalatnama was withdrawn, Lordship. A third line, Lordship. Thereafter on
No,
85,
he is also trying to project that there is a order of the tribunal to the lawyer to communicate. That communication was not made. That is why I'm asking him whether you have made a complaint against the lawyer.
yes,
Because if you're not filing the complaint against the lawyer, that means the order of the tribunal will be sacrosanct. That is page 86, second paragraph.
yes, Lordship.
What is the date of this opinion?
38/2024.
38/24. Ms. Verma, within a month he has come to court.
Lordship may remand it.
My lord, earlier we have also challenged the,
Hmm?
my lord, earlier we have also challenged the impugned ex parte proceeding, which is page number 90.
Page number?
Page number
Page number 90.
90.
90. But during the pendency of the repetition, the tribunal disposed of the matter in ex parte manner.
Oh, acha. Okay. Ms. Verma, this page 91,
Yes, Lord.
290 appeared. He approached this tribunal. We allow this. Your name?
Yes, Abdullah.
S. Abdullah. Heard Mr. S. Abdullah, London Council for the petitioner. Also heard Ms. A. Verma, London Standing Council for the FT Matters and Home Affairs, representing respondent number
2, 5, and 6,
2,
Lordship.
5, and 6. No, 2, 5, and 7.
7.
2, 5, and 7. And Mr. H. Cooley, Leonard Council, appearing on behalf of Mr. A.I. Ali, Standing Council for respondent number 3. And Mr. P. Sharma, an additional senior government advocate, appearing for respondent number 6. No, sorry, 6. There's no representation from respondent number 1 and 4. Next paragraph. By filing this repetition under Article 226 of the Constitution of India, the petitioner has received the ex parte opinion dated 38/2024, passed by the learned member, Foreigners Tribunal, South Salmara, Mankachar, in FT case number 318 of 2018. The Land Council for the petitioner projects that initially due to petitioner's illness, she could not file a written statement and the matter was adjourned. On 9/11/2023, fixing the next date of proceeding on 8/12/2023. Full stop. It is submitted that on 8/2/2024, 7/3/2024, and 8/4/2024, without informing the petitioner, council took adjournment. Full stop. Thereafter, on 18/5/2024, the learned counsel engaged by the petitioner reduced wakalatnama. How the learned tribunal had directed said counsel to serve a notice to the petitioner and inform her about the next date on 17/8/2024, which was not done. And therefore, the matter was fixed for ex parte hearing on 25/7/2024. It is projected that thereafter, the learned counsel for the petitioner had issued a notice on 25/7/2024 and on however, on 25/7/2024, the petitioner appeared before the learned tribunal with a prayer to vacate the order to proceed ex parte, order dated 18/7/2024 to proceed ex parte, and prayed for acceptance of a written statement. So, however, the said prayer was rejected. Full stop. Thereafter, the petitioner had moved this court by filing WPC 4242 of 2024, and the matter was taken up. The matter was called on 2/9/2024. However, by that time, the ex parte opinion was pronounced, for which the said petition was dismissed on withdrawal. with liberty to the petitioner to assail the final opinion. Accordingly, the present writ petition has been filed. Next paragraph. The learned standing counsel for the FT matters and home affairs has opposed the prayer for interference with the ex parte opinion dated 30/8/2024 on the ground that the learned tribunal is required to dispose of the references made before it in a time-bound manner. Therefore, the non-appearance as well as non-participation of the petitioner in the proceedings was at our own risk, and therefore this is a case where there is no evidence at all for which the order of the tribunal does not warrant any interference. Next paragraph. So we take note of the fact that as per order dated 18/5/2024, there was a direction to the learned counsel for the petitioner to serve him a notice. And the next date of the matter was fixed on 18/7/2024. 57. Stop. On 18/7/2024, the learned tribunal has recorded that the engaged counsel is absent without steps. The petitioner is annexed a copy of the notice dated 24/7/2024 issued by a counsel. Which is an annexure 8 of the writ petition. Therefore, this is a case where the order of ex parte, the order to proceed ex parte against the petitioner was passed on 25/7/2024. However, on the same date, the petitioner appeared through the same learned counsel and prayed for setting aside the ex parte opinion, which was rejected. On the ground that the petitioner is blaming her counsel and thereby misleading the tribunal. Accordingly, the petition was rejected. Next paragraph. We also take notice of the fact that against the order to proceed ex parte, and the rejection of petition to participate in the proceedings by order dated 25/7/2024, the petitioner had approached this court by filing the writ petition, and this put by order dated 2/9/2024 allowed the petitioner to withdraw this said writ petition with liberty to assail the opinion rendered in the proceedings of FT case number 318 of 2018. Full stop. Although there is a clear default of the petitioner to take steps on at least 4 dates. But the explanation tendered by the petitioner for non-taking of steps appears to be plausible, and therefore the court is inclined to interfere with the order dated 18/7/2024 and 25/7/2024 passed by the learned member, Foreigners Tribunal, South Sarmara Mankachal, in FT case number 318 of 2018, as well as the ex parte opinion dated 30/8/2024 passed by the said learned tribunal. Next matter is recently, the you just add there, as citizenship is a valuable right, and the petitioner is entitled to get an opportunity of contesting the reference. Next, resultantly, the proceedings of FT case number 318 of 2018 is restored back to the file of the Foreigners Tribunal, South Sarmara Mankachal. Next, the petitioner shall produce a certified copy of this order before the said learned tribunal within within 10 days. 10 days will be within 4/12/2024. And do full stop. On appearance of the petitioner, next paragraph, on appearance of the petitioner, the learned tribunal shall grant feasible opportunity to petitioner to file. You filed your written statement? No.
No.
Just then say on form and file his written statement along with a certified copy of this order. Thereafter, the learned tribunal shall give a reasonable opportunity to the petitioner to read his evidence and read her evidence and dispose of the matter in accordance with law.
Highly okay.
Petition stands allowed at the motion stage without issuance of notice on the respondents.
Highly okay.
Item 13.
Next,
This is an ex parte order, Lordship. Order is at page 19, Lordship. Type copy is at page 16, Lordship.
We give you limited protection not to be deported.
The ends of justice, Lordship. Kindly, Lordship.
Call for the record. Let us see what is your default. Heard Mr. D. Laskar and counsel for the petitioner. Also had Mr. H. Kudi and counsel appearing on behalf of Mr. A.I. Ali, standing counsel for respondent number 2. Mr. A. Verma, and standing counsel for the active matters and home affairs representing respondent number
3 and 6.
3 and
Lordship.
6. And Mr. P. Sharma, and additional senior government advocate appearing for respondent number 5. Next one. Right, following this repression under Article 226 of the Constitution of India, petitioner has said the. Where is the opinion? Which page?
At page 19, Lordship. Type copy is at page 16.
19. This is ex parte.
Yes, Lordship.
This is the ex parte opinion dated 29/1/2022. Passed by the Honorable member for this Tribunal Roman 3, Borpeta. In FT case number page 19, huh? By which the petitioner was declared to be a illegal migrant under the Foreigners Act of 1946. Next, the counsel for the petitioner has submitted that pursuant to the said ex parte opinion, the petitioner was taken into custody on
Lordship. Lordship. 2/9/2024.
29
2024, Lordship.
29/2024. Very high inflation in the country, right? The writing of this date would spend so much of what you call ink that you could not mention that in the cost title. You have saved so much of ink.
No, Lordship. I have
Don't do this. You see, you must make everything easy for us. If we have to search for things, then rely on you. What is the point in presenting? Small things, but you don't take care of those. You have not even written in the cost title that you have been arrested and detained. That simple thing is not there. And then you say that we should be liberal in granting bail. Why should we? Next one. You should notice returnable in 4 weeks. Requisite extra copies of the writ shall be served on the London CCC, State and Departmental Council within 2 days, 2 working days. Next one, that the records be called for. Next one, the prayer for bail shall be considered on receipt of the records. Stop. In the meanwhile, if the petitioner is not yet deported, he should not be deported without an order of the court. Next, the learned standing counsel for the FT matters shall send a downloaded copy of this order to the transit camp, Matia Gwalpara. Expedite. List out of office and receipt of records of the tribunal.
Lordship, I will have to correct this, Lordship.
You can't do it. You will file an application.
Item 14.
May I please, Lordship?
Yes.
In full order, my lord, case.
What is the explanation for coming after 1.5 years? 1 year.
Their poor person, my lord, having no knowledge.
Huh?
Their poor person, my lord, having no knowledge about the consequent, my lord. So,
You've not given any explanation.
Lordship, I have not.
Then you must give some explanation. What is the best document to connect you to your projected parents? Don't show us the voters list, any other document except for voter list.
Stepmother, whose name appeared in 1970 along with father, he deposed before the tribunal.
No,
Stepmother.
that is not acceptable. And any other document to show that
And
to show the name of your projected father.
one document, one voter list is there only. That was also not exhibited before the tribunal. 1985.
What is your name and your father's name?
Afas Ali Ilyas Afasuddin.
Hmm?
Afas
Please repeat again. I'm not hearing it. Afaz-Uddin.
Afasuddin Ilyas Afas Ali. Some voter list Afasuddin, some voter list Afas Ali. 1966, my lord. Afas Ali. At page number 19 and 20.
Your father is there, is not there.
No, he is expired.
He expired when you have given a
Yes.
death certificate.
No, death certificate I have not given, my lord. I have
Then you are just not the member of the family.
about 37 years back. I have given the statement in paragraph number 2.
When did he die? Give us the year according to you. What is the year of your death of your father?
Lordship. It's 87, 88.
You see, then you are not the son of your projected father. Because here in this writ petition, you are projected two Jamabandi. In one, the entry of your projected father is at serial number 10. In the other, it is 107.
Lordship.
So if your father has died, then you are not inherited the property. You are not the son. You bring someone, pick up someone, give evidence that she is the mother, stepmother. It doesn't help you. If you are the son, you must be there in the land. You're not there. So you're not entitled to any protection. Consider it after we receive the records. Because you have 2 plots of land. Why your father will disinherit you, or your other family members will disinherit you.
None of the sibling, my lord.
We don't know. Then your father must be alive. It's unbelievable that somebody would leave the land like that. It's not believable. And I have almost 32 years of experience to tell that. Examine your prayer for bail on receipt of records. Heard Mr. H. A. Ahmed, the counsel for the petitioner. Also heard Ms. A. Verma, and its standing counsel for respondent number for the FT matters and Home Affairs representing respondent number 2 and 6. And Mr. H. Kuli, learned counsel appearing on behalf of Mr. A. I. Ali, standing counsel for respondent number 3. And Mr. P. Sharma, learned additional senior government advocate appearing for respondent number 5. Which page is the opinion?
119, my lord, last page.
Okay, by filing this replacement of Article 226 of the Constitution of India, the petitioner has assailed the opinion dated 29/9/2023, passed by so and so and so and so. Thereby declaring the petitioner to be a foreigner of post 25/3/1971 stream. Issue notice returnable in. Give a fixed date after 4 weeks. Issue notice returnable on so and so. Requisite extra copies of the writ which is served on the landed CGC, State and Departmental Council within 2 working days. Let the relevant records be called for. Next one. Therefore, bail shall be considered on receipt of the tribunal records. Next para. In the meanwhile, in the event the petitioner is apprehended, he shall not be deported without an order of the court. List on so and so.
Hello, please.
Video. 1612, make it.
All right.
Item 16.
My lord, there is some typographical mistake in post title, my lord.
Okay.
My-
What is that?
about her
What
name.
is the mistake?
My lord, she has already has 3 allies, my lord. Khateja Khatun, Khateja Bewa, Khatun Bibi, but wrongly typed as Khatub Bibi. It should be Khatun Bibi. That mistake, my lord.
No, but then you have to get it corrected.
I will file it.
Okay. Okay. Mr. A.R. Sigdat, counsel, both sides are represented. Mr. A.R. Sigdat, counsel for the petitioner has submitted that there is inadvertent typographical error in the name of the petitioner. Stop. And accordingly, he is permitted to file a corrected cost title in respect of the name of the petitioner. To submit so before the AOJ, FT unit. Thereafter, the matter will be listed in the motion column.
My lord, we only require to file corrected cost title.
Page 2.
Yes, my lord.
Page 2 is the mistake.
My lord.
On the cost title.
My
cost title.
Igloo.
Because under the High Court rules now amended, you have to submit a.
Item 17.
May I please, your lordship?
Yes.
The petitioner is my lord Rajabali, my lord, and his father is my lord Abdul Mafid,
Just
lordship
a
will-
moment.
my lord.
Which page is the opinion?
Opinion is at page, my lord. 63, my lord.
60?
Annexure 12, my lord.
63?
3, my lord.
What is the best document you have to connect it to your projected
Lordship
parents?
will kindly have a look at page 19, the voter list of 1966.
No, apart from voter list,
Apart from voter list, my lord, the only land document is, my lord,
because I have a voter list of the former Prime Minister of India. He was from Assam.
my lord.
He was from Guwahati. I have his cause list.
My lord, the land documents are in the name of father as well as the grandmother, my lord. The land documents, my lord.
Land documents.
Land document is in the name of father, my lord.
Where is that?
Page 37 is the vernacular, 36 is the translated.
And how you have connected yourself to your
Along with the
projected parents?
electoral photo identity card and the voter list of the petitioner.
You are with your father.
Yes.
You are with your father. Voters list, you are there with your father.
No, my lord, single name voter list, my lord, but from the same village, the
Then-
father names is so similar.
Then you are not a
Electoral
family
photo ID
member.
card is also there, my lord. Page 27, lordship will kindly have a look.
Where is that?
Page 27 is the voter ID card, my lord.
27.
My lord. The name of the
Is,
petition.
is it after 1997?
It is after 1997, the voter ID card, but the voter list, my lord, the 1989, the just previous page, my lord.
89.
Yes, my lord, the page number is 26, my lord, the previous page. The voter list of 1989 of the petitioner, my lord, Rajabali. He was 22 years old, my lord. then. From same village.
Because the difficulty is that we don't know the family members. In your written statement, have you said about your family members?
Yes, my lord.
Where is that?
My lord, can you have a look? At page, my lord, 44, annexure 7, my lord.
Single voter list means that you want to mask your other family members.
No, my lord, I have already clearly stated, my lord.
Which
Right from
page?
page 44, my lord.
44.
My lord. Right from para 5, 6, and 7, I stated.
You don't have siblings.
Regarding siblings, I think,
You don't have siblings.
Abdul Mufid.
Lordship, one voters list to show his name with his siblings, Lordship, because he is 68 born. So there ought to be a voters list with his other siblings and parents, Lordship.
It doesn't say about the siblings at all.
In his cross, Lordship, at page 53. Lordship may come to page 53,
yes,
Lordship.
53.
53, he has given some information, Lordship,
Yes.
which ought to have come in his written statement. But written
That
statement
was
is
not
silent
actually-
about all family
Will
members.
produce melody if it is there, my lord. Lordship, at this stage, I have a humble prayer before the lordship, my lord. Lordship will kindly protect me, my lord.
Lordship,
otherwise, Lord,
he's
I'll-
saying it's
There's
not
a difficulty in
necessary,
production.
Lordship.
Lord, I'll produce the necessary, my lord, voter list, my lord, by filing an additional affidavit, my lord. But at this stage,
No
Lordship will
interim
kindly
at
protect
this
me.
stage, Lordship,
my
let LCR
Because
come.
Otherwise, my
Otherwise,
lord,
the
the linkage is
difficulty.
clear, my lord. The member of the learned tribunal, my lord, he has held that the father's name was wrongly, my lord, spelled out in the voter list of 1970, my lord. Against the, my lord, mother's name as Ang Motlib Mia, my lord. This is the first reason, my lord. In the voter list of 1970, page 22, my lord. Lordship will kindly have a look.
Lordship,
It's been
what
very clear.
stopped him from filing his family details in the
Yes, my lord,
voters,
I
in
admit
the
that that
WS,
should have been
Lordship.
explained, my lord, in WS.
Okay, we'll consider it on the next date. Let the records
After
come.
LCR is received, Lordship will.
In the meantime, you file it. Let us see who are your family members are.
Because my lord, those were not executed before the concerned tribunal, my lord, that is why my lord, at this stage.
No,
my lord,
unexecuted
my lord, I'll
documents also,
furnish it in the form
we
of
look
petition.
into it unless, if you make it very clear that these are unexecuted documents, we still look into it.
My lord, I'll definitely, my lord. If it is there, my lord, I'll furnish it.
We are disturbed only when somebody does not tell us that we are looking into a document which is
Yes,
unexecuted.
Right.
Then we get confused. We are reading the opinion of the tribunal, this document is not there, then there is a document which is being referred. So we can't match.
My
And
lord,
therefore,
not the Lala's tribunal, my lord, they did not, my lord, disbelieve it. But regarding the voter list of
we are not
1970,
believing it.
the only, my lord, mistake is there, my lord, in the name of father, my lord. That was rightly, my lord, spelled out. The name against the mother's name, his father's name was, my lord, only Mia was, my lord, added, my lord.
No, it's
That
okay,
is not-
we are not very satisfied.
My lord,
We'll consider your prayer for bail on the next date.
my lord.
Like the previous order, consideration of bail on the next date. Huh? By Mr. Z. Ahmed, Hamad, Hamad, Learned counsel for the petitioner. Also heard Ms. A. Verma, and standing counsel for the FT matters in home affairs, representing respondent number 2 and 6. Mr. H. Puri, learned counsel appearing on behalf of Mr. A. Ali, standing counsel for respondent number 4, and Mr. P. Sharma, and additional senior committee advocate appearing for respondent number 5. Filing this writ petition, the petitioner has assailed the opinion dated 29/6/2024, page 63, passed by so-and-so in so-and-so. Corresponding to SP inquiry number so-and-so. By which the petitioner was declared to be a foreigner of post 25/3/1971 stream. Issue notice returnable on 16/12/2024. Requisite extra copies of the writ petition be served on the CGC, Common State and Departmental Council within 2 days. Not for the records. Prayer for bail shall be considered on the next date or on receipt of the records. Next paragraph. In the meanwhile, in the event the petitioner is apprehended, he shall not be deported without the order of the court. Next paragraph. List on 16/12/2024.
Give the writ.
Item 18,
May I please, your lordship? The matter may be taken up after some time. My senior is visited.
Sometime.
Sometime we have to review it of the minds.
item 19,
Position. You have to call it, otherwise. You do anything. Anyways, like, it's more sense, you know. Procedure. You will be lying the registry to. Always coming to it. Talk with me, that's why I asked you. And since. So we have to be curious to go. Instruction paisa. No. Yes, they definitely.
May I please, Lord? My lord, opinion at page 68, my lord.
How you explain the
I
delay?
have stated in para 4, my lord.
Para 4.
4.
It's not like
Okay, what is the best document you have with
Best
your
documents, my lord, Kabinama at page 38, my lord. Exhibit 9.
38?
8. Firoza Begum, my lord, she is the petitioner, and father's name is Surjot Ali.
There's something we can't read. You have a better copy.
Yes, my lord, I have.
What is the date of marriage from here? How you can find out what is the date of marriage and what is the date of
19789, here. Bottom person. Written in Assamese.
Does not play any public but any Muslim who received and the Muslim other than wife or valid document size. But no other document to show that the father. WS was not BBC. Right. Lordship.
producing a Kabinama. Give him introduction for the time being.
In his lordship. At 72, the member has put in his views, lordship. OP did not file any public document pertaining to herself and her husband. other than exhibit 9, which indirectly proves that she is the daughter of so and so, and therefore not a testimony of her citizenship under any of the modus ex facie leading to its rejection is found unreliable. The issue to be decided with. There's not a single document of hers with her projected father, Lordship, or
So
her
that-
siblings. Lordship may call for the records, Lordship.
But his brother has come as
Elder, but
witness. He shows what was this along with his father.
yes, that is case
Whether
25.
that brother is projected brother or own brother, Lordship, we'll have to look into that.
That's right. Since he's producing a Kabinama, we give him some interim protection.
Kabinnama is only to prove with the husband, Lordship. Father's name may just pop up.
But it's an 89 document. That's why.
But it has not been proved. The Qazi has not been called, Lordship. It's a motion stage.
You are right. That damages the evidence, but still. Under the act, it is the registrar who has to come and
Yes,
prove it.
prove the document, Lordship.
You are right there. But
And even serial 11, the member writes, Lordship, during the two different spells of residency in Assam, OP's father and mother came on record together as husband and wife from one household in 1997, but not before that, Lordship. Maybe that
Right.
continuous stay also will have to be looked into.
you're right, but we are only looking at this page 20,
Yes, Lordship.
first line. That is the main reason to.
Lordship may decide on, let the records come, Lordship.
Let it be, we'll decide, but
Yes,
the age
maybe
is,
let the records come at
Age
the
is-
earliest.
age is 60 years, we don't want.
And the
Remains right.
opinion has been just passed, Lordship. It's a 23 opinion.
It's only that reason, nothing else.
Leave it to your Lordship. And not to be deported, Lordship may put it that way.
60 years, we give us some protection. 60 years, we. Sixty years, she let her have some liberty for some days, till we don't hear the matter. Merit we have already discussed. Merit we have already discussed. Still. Mr. S. A. Ahmed, well, counsel for the.
98 IMDT matter, Lordship. Her whole life has gone comfortably in Assam, Lordship.
Yes. Ms. Ahmed, we don't have a case, but it's only because of this age protecting you. That is S. A. Ahmed, and counsel for the petitioner. Also heard. P. Barwara, that
What do your Lordship?
standing counsel for respondent number 2, it's A. Verma, and it's standing counsel for respondent number
3 and 6.
3 and 6. And Mr. P. Sharma, and an additional senior government advocate appearing for respondent number 5. So there's no representation from respondent number 1 and 4. Filing the petition under Article 226, the Constitution of India, so the petitioner has assailed the opinion dated 7/1/2023, passed by the learned member of Foreigners Tribunal 11th of Borpeta, Sarvog, in FT case number 1851. Which page is the opinion?
My lord, page 69. 68, my lord. 68, 6H.
68.
And it start from 69.
Okay. RP so and so and so and so, arising out of reference number 1799/B/98. By which the she was declared to be a foreigner of post 25/3/1971 stream. Issue notice returnable in 4 weeks. Extra copies within 2 days, 2 working days. Call for the records. Next, the petitioner shall appear before the Superintendent of Police, border Borpeta, within 10 days. Furnish bill bond rupees 5,000 with all those conditions. It's made clear that if the petitioner fails to appear before this Superintendent of Police, Borpeta, and take bail within the time allowed, the other bail shall stand lapsed by reflux of time. The Kabinama we are telling. This after 4 weeks. On receipt of records.
Oblige me.
NRC, my lord, page 21.
21.
Yes, my lord.
Issued when?
Issued in before 1951.
No, it can't be before. If it is before, then it's a manufactured document.
My lord, original is with me, my lord. That is so old
No, but
document.
NRC before 51 is something we don't know.
Yes, my lord,
So
I am
if it
just a relation. I am just trying to relate how is the link, yes, my lord.
Lordship,
Subsequent, my
this President Secretary District Congress Committee is not the authorized person
No,
to
that is-
issue this NRC record, Lordship. First,
it is just my lord. A
no,
fact,
whatever it is, Lordship,
correct,
this
you're right.
fact is discarded.
and
Because Mr. Ahmed, you are asking for the best document.
yes, my lord. That is, my lord. One is 66 voter list, my lord, where mother's name is
60
there.
66.
My lord, before that, my lord, fact is peculiar, my lord. May I read? May I
Yes,
pledge the relationship with the family members?
yes.
My lord, immediately, my lord, before title page, I have annexed the family tree, my lord.
No, that would depend on what you have said in your written statement.
Written, yes, my lord. I have stated that.
Before title page is something which is not bound by affidavit.
Yes, my lord.
So something, this is best.
My lord, in my WS, my lord, I stated page 45, my lord. Paragraph 12, my lord. Before that, my lord, my mother was married with another person.
You absolutely nothing to connect.
My lord, that is, my lord, one, may I just one land document is there, my lord, Jamabundi, my lord, at page 30, my lord.
30.
Serial number 7, my lord, is the name of mother.
You do get your documents side here, no? Side.
My name is mutated in, my lord.
E2 দিছে 8 নম্বর মার্ক এটু 60 কইছে আমি ইয়াতে লিখাইলে 86 E2 83
Last one. 86. Village to key.
Double A para. Original village.
Photostep na
ঠিক ফাইল নিয়ে এগুলা কনফেকশন
Elder brother from elder others. Transfer. That is the reason behind.
And the children are from which father?
Second father.
Naya Ben Shahib.
Naib and Shahid from Khobir. Khobir's name is not there, but in total list, Khobir's name is there.
Yeah, so that land has to be Khabiruddin's. Find it? Yeah, it in the- No. Can you just explain who is this Salimia? Salimia?
Second time married with Khabir and third time also Moizuddin.
We are not satisfied with the linkage you are trying to show.
My lord,
It's quite confusing, Lordship.
is-
He says the mother married thrice.
thrice my
First husband and third husband's name is same. And the second husband, so I asked him, the children are from which husband? Both the boys, Shahib and,
Sahib and Naib
Naib.
is from the
because
Because then there's a
Second-
disconnect with the mother.
Mm.
The reason is that Mr. Ahmed was kind enough to show us the Jamabandi. Now the Jamabandi, you come to English
yes,
30, page 30. Kanchan Nesa,
yes, Lordship.
wife of Mayajuddin.
Moizuddin.
Now, this,
And sons are from,
And
this,
in remark column, my lord,
this page 31,
31.
Gha is Mayajuddin.
And son of Khabiruddin, my lord.
and when did
Khabiruddin was the
father
second
passed
husband.
away,
of-
Lordship?
Yes.
When did the father pass away? And it was mutated in 86.
Mr. Counsel,
My lord.
Ungo is not fully
Yes.
translated.
My lord,
No, Ungo is not fully translated. Come to page 34. Read.
Ungo.
Hmm.
শিঠার উপপ্রতি সমাহর্তার ৫/৫ 86 ইং তারিখৰ হুকুম মতে উত্তরাধিকারী সূত্রে পটাৰ 327 নং দাগে কাঞ্চন নেচাৰ স্থলত সাহেব আলী 2 নম্বৰ মোহাম্মদ নাইব আলী the petitioner উক্ত উভয়ৰ পিতৃ মৃত খবির উদ্দিন
No, there is 3 also, Muhammad Rahanar Desa.
রাহা-
4 also, 5 also. Pita Moizuddin.
they are not related to us, Your Honor.
Why you have translated half?
In that translation portion, my lord, I have written
have read
relevant
half.
portion, my lord.
Because there it is Pita Moizuddin. 3 Raftan Nisa, Mukhtar Ali, Zalekuddin. Their father is Moizuddin.
Yes, my lord.
Because your mother is different. Your mother is the wife of somebody else. That is the disconnect.
My lord, Saheb Ali and Naib Ali is the
So first
son
of all, you see, we are relying on you. You say that it's a true copy of the translation and it is not. We refuse to entertain the petition. We just adjourn it. We will not encourage this. Both sides are represented as Annexure 6 is not correctly translated. The court is disinclined to take up the matter. Matter stands adjourned today. We grant liberty to the petitioner to file additional affidavit and bring on record the corrected translated copy.
only that document, my lord.
We don't know.
My lord.
This is one document we have
My lord.
read. If there are other documents, next day we find, we'll again adjourn it. You don't expect us to go home and then read every translation and then correctly certify whether you have given it true or not. You expect that? You do your own homework.
My lord. Obliged.
Item 21.
Yes, expansion lordship, page 25 lordship. Page 25, paragraph 22, I have tried to explain lordship. With the satisfaction.
But
of
the
the
explanation is not acceptable. Your husband went somewhere.
Lordship, actually both. The petitioner and her husband both went to Delhi lordship. During the COVID, there was a hardship lordship. And during the time of COVID, the judgment was pronounced. At that time, thereafter they went to Delhi lordship. to work in the brick field. And thereafter they came back, they are very poor person, Lordship, BPL families. So now they have approached this honorable court as they have instructed us, Lordship, as per their instruction.
It's not a very good explanation to entitle you to bail.
Lordship, lady is at about 52 years with family, Lordship, illiterate old lady, Lordship, working in the brick field and some other places, Lordship, to earn livelihood for herself and her family, Lordship. So that may be.
52 is no age at all. Every day there is a sports of for persons who are more than 90.
Lordship. But in the rural areas, Lordship, they, due to the childbirth, etc., they become physically weak also, Lordship, at this
But this explanation is not good.
Maybe condone, Lordship. Humble submission, Lordship.
What is the opinion?
Opinion starts from page 99, Lordship.
And there is no connect. In fact, the link documents all have those what you call
State emblem, Lordship.
state emblem.
Lordship, that my submission is that that is the issue of the Panchayat department, Lordship, the old layman work. So how they can know, Lordship, that whether this is mandatory or not? That is fault on the part of issuing authority. I bona fide approach for the certificate they issued after verification, Lordship. So I relied on this document in the tribunal, Lordship. And the Panchayat secretary also came to depose, Lordship, from Mankacha to Boko, Lordship. That is at page 58, Lordship, with evidence as CW1, Lordship. And the application is also, the copy of the application was also submitted by the GP secretary before the tribunal, that on the basis of this application, I have issued the certificate. And page 110 is the said certificate, said application, Lordship, which is supported by two respectable persons from the locality.
No, but you see, your family is not together in the voters list also.
Lordship, yes,
There are
due
many
to lack of
gaps.
proper instruction, Lordship, the single name voter list was obtained and
Then-
submitted. And subsequently, the OP has obtained the full list also, Lordship. I have annexed those document for the perusal of this honorable court, Lordship, after the impugn opinion, Lordship. These are the actual voter list, page 114, Lordship. These were obtained subsequently, but at the time of the proceeding, Lordship, the single name voter list was obtained under the instruction of the council due to wrong instruction, maybe, Lordship. Page 115 is with the name of three persons, Lordship. The grandfather and father, grandparents and father
Page?
of the page, Lordship, 115. This is subsequently obtained, wherein the full family name are there, Lordship. Page 115, this is voter list of 1970, Lordship. Herein the name of Iman Ali Sheikh, this is the grandfather, Lordship. Grandmother Bindu Nessa Bibi, and A Hussein. A Hussein is Abul Hussein is my father, Lordship. So before the tribunal, only the voter list in respect of name of A Hussein was furnished, Lordship, due to lack
No,
of
this is of which year?
1970, Lordship. Page 114.
115. Is of which year?
Yes, 114 is the first page of the voter list. 114 is the starting page.
Exhibited.
1970.
Yes.
And what is any other document to connect you to your projected parents?
Any other document, Lordship? There was a Kabinnama, Lordship, that was given to the council, but he did not exhibit it due to reasons known to him. I have tried to place this before this court, Lordship, honorable court. That is page 121. That was not before the tribunal at the time of the proceeding, Lordship. This was given to the council, but the council stated that this EP certificate along with the evidence of the GP secretary will suffice. So herein, at page 121, Lordship, the date of marriage is 25/10/96, Lordship. This is all document. And herein, the name, the page 121 is the original vernacular, Lordship. Her name is there, her father's name is there. So this was not before the tribunal. Before the tribunal was the GP secretary and the evidence of the Panchayat secretary.
Where are the voters list?
Worship, the other voter list are of
1966.
yes, Lordship. 66 is in respect of her grandfather, Lordship. Iman Ali Sheikh and Bindu Nessa Baby, page 59, Lordship. Starting from 1966 onward, 1970 I have already stated before your Lordship. 1977 is also their Lordship at page 63. They are in Abu Hussein and Malik Jan. These are her parents. And thereafter, Lordship, 1985, Abu Hussein and Malik Jan, page 65, Lordship. Abu Hussein and Malik Jan both expired, Lordship, long back. And thereafter, Lordship, 89. And her voter list are also their Lordship. From page 75 onwards, this is Chan Banu Nessa.
Not,
That proposed.
no, it's not the contents. वो हुआ है ना पंचायत तो डूबे हुए हैं because we it was not 106 it हुई है
Your discussion.
So saying we are not finding a connect.
Lordship,
You're not finding a connect to give you a bail.
Lordship, admittedly only this document is there, Panchayat certificate, and this is unexhibited, this governing option. But due to some fault on part of the council, Lordship, due to
Because for
ignorance
20
of
years, there's no explanation.
Lordship.
If she's 40 years in 2013, she'd be born in 1973. So 1994, she becomes 21 years. The voters, she becomes a voter at 18 or 21.
In the
After 89 lordship, it was
21,
years,
18.
Yes, Lord.
After 89, it is 18.
Your Lordship, she tried to enroll her name in the voter list, but that was not allowed. That
Hmm?
was not- So actually, she tried to enroll her name in the voter list, but as she was working out. For this reason, there is some delay in the, and as regards
So even
the,
the village and all, we are trying to make our calculation, but we are not finding there's a connect. Because suddenly your sister comes,
parents,
you are given a single voters list. You can't connect from
single-
voters list of 2015.
Page Lordship 93, this is uncertified copy annexed with the record Lordship in the tribunal. Here in the entire family of her and her in-laws are there. But as I have submitted already Lordship, due to lack of instruction, single name voter list
98.
adopted.
Which page?
2013, this is page 93 Lordship. Type copy, and the 94 is the uncertified 11 page Lordship. Herein against the from serial number 24 onwards, Lordship, house number 5 co. 24 Lordship. 24 is
This
the
is not with
island
your, not with your, in your parents' home.
Lordship.
This could not be in your parents' home.
Oh, yes, Lordship, this could not be. This is with my in-laws, Lordship. After marriage, my name was actually recorded
We
with
just
my.
wanted to have a connect.
Yes, Lordship, here is no connection with my parents.
Connection.
After marriage only, my name was enlisted in the voter list. Lordship. in this matrimonial place.
We are examining it only for the purpose of bail. We are not finding it to be a good case for bail.
The Panchayat Secretary also came and deposed.
Lordship may examine the matter, Lordship, and after receipt of LCR, Lordship may consider the interim.
Her parents have expired, Lordship, and her brother also expired, so she could not bring any elder person from her family, Lordship. And as such, she relied on the GP Secretary, Lordship. GP Secretary was kind enough to come travel to this tribunal.
No, it's okay, but if you see the entire footage is there, we would have understood that there's no family members. Now there's absence and then you say that you had no siblings.
No, sibling I have, Lordship. I have sibling, but my parents expired, my elder brother also expired, Lordship. So there is no elder one to come and depose in my favor.
No, that's okay, but somebody of your family.
Voters list together, Lordship.
Some
We are not
voters
finding
together.
that also.
Your only one sister has come in the voters list. Step sister.
Yes, Lordship. She is from that place, Lordship. And she is younger, Lordship.
But still the connect is not there. We're trying to connect it to your projected parents.
Lordship, none of the documents have the linkage, Lordship. None of the documents except the panchayat, and which is not
Consider a bail
admissible.
on the next date. Let us have the records. But Mr. Zaid Hussain, done at counsel for the petitioner, also had A. Verma and its standing counsel for the FTN Home Affairs representing respondent number 2 and 6,
Six, Lordship.
and Mr. H. Kuli, done at counsel appearing on behalf of Mr. A. Ali, standing counsel for respondent number 3.
Right.
And Mr. P. Sharma and an additional senior government advocate appearing for respondent number 5. There's no representation from respondent number 1 and 4. Finding this representation under Article 226 of the Constitution of India, petitioner has assailed. Where is the opinion?
Opinion, Lordship, page 99.
Page
99.
Page number 99. Opinion dated 25/3/2021. Passed by the London member, Foreigners Tribunal number 2, Kamrup at Boko, in BFT case number 419 of 2018, arising out of so and so and so and so. By which the petitioner has been declared to be a foreigner for post 25/3/1971 stream. Issue notice returnable in 16/12/2021. Requisite extra copies of the petition is served on London State. London CEC, State and Department Council within 2 days, 2 working days. The relevant records be requisitioned from the concerned tribunal. Next, by the prayer for bail shall be considered on receipt of records. Next, however, it is provided that in the event the petitioner is apprehended, she shall not be deported without order of the court. Next, list on 16/12/2024.
Item 8.
Yes, my lord.
Yes, what is your explanation for 2 years delay?
My lord, petitioners house were burned out, my lord, in the month of
Huh?
April 2022. Their house were
Page,
page 20, my lord, para 26, my lord.
page 20.
Yes.
Page 20, yes.
Yes, para 26, my lord. My lord, petitioner linked to his father, my lord, exhibited one school certificate, my lord. So that document was not proved, my lord. Page 39, my lord. School transfer certificate. My lord. And my lord, petitioner father also deposed before the tribunal as my lord DW3, my lord. And my lord, Gangura certificate, my lord, from his parental house, my lord. Gangura also adduces evidence before the tribunal as DW2, my lord.
Government evidence is of no use because the document contains state emblem.
My
You see, you find nothing in this matter. My esteemed brother has pointed out page 27.
my lord, in WS. My lord.
Pardon me?
My lord only stated that she is the daughter
That's all.
of his grandfather name also.
But then nothing is there.
One page of written statement.
The only reliance is on the government certificate, except for that, nothing else.
My father deposed before the tribunal, my lord. As DW3, my lord.
You see, father has not been tracked to anywhere. Where is your father's deposition?
My lord, lordship made on page 60, my lord, 60.
He also says nothing.
My lord, in Puros part, my lord, that is page 66, my lord.
There, my lord, family.
No, it doesn't even say about his identity.
My lord, page 66, my lord.
Page 66.
Yes, my lord.
When the proceedings, father's name appeared for the first time in the voter list?
My lord, so, it's appeared earlier, my lord, only one voter list was exhibited of the 1998, my lord. Before the tribunal, my lord, but one cell deed was exhibited, my lord, that is back
When
to.
his name was first
My lord,
appeared?
I have not that information, my lord, but as per information,
What voter list for your projected father has been exhibited?
1998, my lord.
Which one? Page?
Page 34, my lord.
This is the first statement I have ever come across where your father comes and says that he has a brother and the brother has an adoptive mother. Adoption of a son I have understood, but to adopt a mother. You have read it? No. Come to page 66. About in the middle, about 10 lines from below. Barik, our parents died at the tender age. After death of our parents, Gani Master and his wife Samsun Nair take together Abdul Barik. Barik is considered as their son. Barik is now alive. Gani Master is so and so. Oh no, before that, in the middle. Gani Master is the adopted father of Abdul Barik, being the younger brother to me. Samsun Nair is the adopted mother of Abdul Barik.
Lordship, the father in his deposition at page 61 says that he is voting since 1985. And the 1997 one and this name, there are discrepancies there, Lordship. The one which my friend has referred to at page 34.
Yes.
Page 34, he is shown as A. Ghaffur. And in his deposition at page 61, here he says that I am the father of the proceedee, having been casting votes since the year 1985. So, and his name is A. Ghaffur here. Somewhere it's written Abdul Ghaffur. And somewhere it's written A. Ghaffur, Lordship. And Rushmat, and the father's name is Rashmat. Rashmat Ali.
Spelling the.
Oh,
Too much
Mr.
into that.
Counsel, come to page 63. Paragraph 3.
Lordship.
এই গোচৰৰ প্ৰতিপক্ষ মাজেদা খাতুন মোৰ ছোৱালী হয়।
My lord.
তাইৰ মাকৰ নাম শামছুন নেহাৰ।
My lord.
So this is DW3.
Yes, my lord.
Now, is it page 66 is his cross-examination?
Yes, my lord.
Now read. Mazeda Khatun is my fourth number daughter. I
Yes,
have
my lord.
seven
I
daughters,
have
two
7
sons.
daughters, 2 sons.
Samsun Nehar
Mother of-
is the mother of Mazeda. He is my wife.
Yes, my lord.
Then
Mm,
Meherun Nisa is my wife. I have only one wife.
My lord. My lord,
So
later,
who is the wife?
no, my lord, later on, my lord, it is stated that Mehrun Nessa and
Oh.
Samsunar is the same and
Meherun Nisa changed her name to
my lord,
Mazeda.
my lord.
Interest.
Lordship, the documents would have been like that, picked and choose, so whichever suited, that name
Very-
became, that is happening, Lordship.
Quite interesting.
No, my lord. If lordship may come to my lord, just send it.
Samsun Nisa to Mazeda Khatun.
If lordship
They
may
had
come
to
to
mix
take
and match with the
30,
documents, Lordship.
No, we will have one regret in life. So nobody changed our name. We are saddled with only one name for the entire life.
if lordship may pays to come 32, my lord, this is the sale deed, my lord, of the year 1982, my lord, where petitioner
We will
parents.
consider a bail on receipt of record if you're not satisfied.
My lordship, it's upon me.
You find a lot of
Right.
gap here.
My lord.
Your written statement has destroyed everything
Yes, my lord.
because you'll have to prove only what you say. Your written statement is,
Still nothing.
I don't know how people are being advising.
That is the safest, Lordship. Written statement vague is the safest. They have time to build up the case over the years, Lordship. They file written statement in 1 year, after 7, 8, 10 adjournments, they come with the evidence, more documents, then again some more documents, then again additional WS. So Lordship, it gives them lot of time over the year to get the documents they need, Lordship.
Mazeda become Samru.
Samsun, Majida and all become clubbed into one, Lordship.
No, my lord. Sometime what happened, they, at the time when the notice received, they actually didn't possess any document, my lord. The document, collection of documents took some time, my lord.
No collection in the sense, Lordship.
It is there.
Yes,
Yes,
It is
Lordship.
there, Mr. Counsel.
My-
Document is not there. It
Yes,
is there.
yes.
But my lord, sometime,
Is
my
it
lord,
not?
parents' name wrongly
That
appeared in the
explanation
voter
is
list.
quite poor explanation. Sister's name, mother's name, father's name, it is all
Right.
there. Not in the, not required to be.
Documents. Yes, Lordship. ये हो तुम्हारा बहुत देर सुन रही है. I was watching here. Auto pala. I was watching it. It's always good. And you are, if it was on record, that was.
Consider a bail letter.
My lord.
I'm not satisfied at all. Had Mr. K.M. Hassan, the counsel for the petitioner, also heard Ms. P. Barbar and its standing counsel for respondent number 2, Ms. A. Verma and its standing counsel for the FT Matters and Home Affairs representing respondent number 3, 4, and 7. And Mr. P. Sharma and an additional senior government advocate appearing for respondent number 6. So there is no representation from respondent number 1 and 5. Next paragraph. Page 69. Find this repression under Article 226 of the Constitution of India, comma, the petitioner has assailed the opinion dated 3/2/2022 passed by so and so in so and so, thereby declaring the petitioner to be a foreigner of post 25/3/1971. Last line will be before finding that the petitioner has failed to discharge a burden under Section 9 of the Foreigners Act of 1946. Next. Next, the explanation tendered by the learned counsel for the petitioner that the house of the petitioner was burnt out in the year 2022, for which they were facing financial crunch, for which there's some delay in approaching this court. It's accepted as a good cause for delayed challenge to the impure opinion. Next issue notice, returnable in 4 weeks. Make it 17/12. Requisite extra copies of the petition be served on the run at CEC, State and Department Council within 2 working days. That the records be requisitioned from the Learned Tribunal. Next, therefore, bill shall be considered on receipt of records. Next, in the meantime, if the petitioner is apprehended, he shall not be deported without order of the court. List on 17/12/2024. List.
Item 23 for admission.
23.
No representation from the petitioner. For the justice in matter stands adjourned today. List after 2 weeks.
Item 25.
Okay, I don't have the file lordship.
Hmm?
I don't have the file lordship, if possible lordship, day after tomorrow. I have to reconstruct it.
May I say one thing, my lord? Since my lord is filed on 2018, my lord, and the petitioner is 76 at that point of time, my lord. So may I take some instructions, my lord? Because I tried to contact on his phone number, but it was not in service, my lord.
Okay.
Because he's in.
How much time?
My lord,
How much time?
2 weeks, 3 weeks, my lord.
And it will be 4 weeks.
4 weeks.
Okay. Both sides are represented. So on the prayer made by learned counsel for the petitioner as well as for the respondent number 3. The matter stands adjourned today, list after 4 weeks.
Interim may be continued. They were interim, my lord, protection
Interview don't need an extension.
until the next date, my lord. It was not.
Okay. Okay. The interim order passed on 26/9/2018 stands extended till the next date. Listing.
Oblige, my lord.
26.
No one is there. Okay. No, John Francis.
Item 27.
May I please your lordship, this is a contestant case. Lordship, in this case, petitioner father Usman Ali name appeared in the voter list of 1966, page 39.
Just a moment.
Lordship.
So the difficulty is that none of your family members came and deposed in your favor.
Lordship, only Gaubura.
Gaubura did not bring any record.
Lordship,
He did not prove his identity also.
Gaubura issued a certificate in favor of the petitioner, Lordship, and DW2 Gaubura also examined. Kaubura certificate page 56.
Hmm?
Kaubura certificate page 56.
No, but you see, this Gabura,
Lordship.
he did not bring the counterfile. He did not prove the original one. It's a পনেরো কথা আছে Mr. Sharma, you have examined the records?
They are not similar.
You just see this record. In fact, even if you don't see this record, it would not matter.
Where's the lodging? There was no link.
Hmm?
There was no link.
This, you have a wonderful tribunal. The link which was not there is connected by the tribunal itself. And you and the state government does not want to train them. You want to know how the wonderful tribunal has assisted in this matter. Had discharged his duty, not assisted. Discharged his duty in the matter. You come to page 28. This is a person who knows. He's not a family member. Page 27.
Yes.
Hmm? And he's the Gambura,
Yes, Lordship.
correct? He knows her. Now, you come to page 32. This is the answer to the queries. Correct. Page 32,
Yes, Lordship.
answer to the queries.
Hmm.
Now, in this, he gives us false statement. But the tribunal does not bother to confront him. Page 33. 1960, last about 6 lines, 7 lines. 1966 সনর
ভোটার তালিকাত
ভোটার
বিপরীত
তালিকাত
পক্ষৰ
বিপরীত পক্ষৰ
মাকৰ নাম
মাকৰ
দেউতাকৰ
নাম
লগত উল্লেখ আছে।
উল্লেখ আছে. Now the document is at page 40.
Yes,
Mother's name is not there.
yes, Lordship.
But the tribunal does not ask him that this is a false statement.
Yes, yes, Lordship.
So therefore it is confirmation. Even if it is not there, your tribunal brings it. The link to the father and mother is there. Although it's not the case of the petitioner. Somebody comes and gives a better evidence recorded by the tribunal. And then it is discarded on the ground that the Gambra did not bring the counterfoil.
Yes.
But there is a question you'll have to answer. You see, how do you call a witness? And why do you call a witness? Answer to how is that you give a summon. And in the foreigners tribunal cases, there are a lot of decisions which says that first it is the proceeding who will have to take steps. And on his failure or refusal of the witness, then comes to the tribunal. Correct? Now, if A as a proceedee wants to prove something, he brings a witness. And if the tribunal wants something more, that you bring the counterfoil, will you have to ask the witness to bring it? Now, let us say, take an NDPS case or a postmortem report or anything strange which you want to think of. And now an expert comes and says that he has done the postmortem and he has found this is in the viscera. Can you ask him whether you have brought the viscera today? Or do you call what you call the circle officer and ask him for the question of mutation? Okay, you passed an order of mutation in 1977. What is the document based on which it was done? Have you brought those documents? Can that be a question? He gives a certificate, he proves that certificate, that the certificate issued by me. He said counterfeit is not brought. You should have asked him to bring it, pass an order, giving a direction to bring it. How will the witness carry something which he does not know is required to be produced? Is it a fair trial? This is a query you satisfy next week. There will be two queries. Your supporting witness comes and then deposes. He gives a false statement, but nobody knows how to catch him. And I'm extremely fortunate today that my brother has some experience there, and therefore he got this discrepancy immediately. Next week, you'll be ready with these answers.
For sure.
Listing it next Wednesday. Both sides are represented. It is noticed that in the impugned opinion dated 21/6/2018, the Gambura certificate within bracket Exhibit F was discarded, although the Gambura had deposed as DW2 on the ground that he has not submitted the issue register containing the counterfile of the certificate. And therefore, his evidence was found to be unreliable. First of- Moreover, it appears from the records received from the learned tribunal that the petitioner who was examined as DW, who examined herself as DW1, and the Gavra who was examined as DW2, were put questions by the tribunal the DW2 in examination by the tribunal had given a statement that the name of the mother of the petitioner appeared in the 1966 voter list along with the name of her father, which is not borne by Exhibit A, which is the certified copy of the voter list of 1966. However, the said DW2 was not confronted with the contents of Exhibit A. In the examination of DW1 by the member from a foreigners tribunal. There is no question with regard to the parents or grandfather. Stop. If under such circumstances, the learned standing counsel for the foreigners tribunal shall address the court as to the impact of the above. This was on the aforesaid aspect. Only that much. Mr. Matterson is adjourned today, list on 27/11/2024.
Can it be lordship after 27? Can it be after 27 or before 27? Yes, yes, lordship.
Item 26.
We examine the records.
Lordship, today I have nothing, Lordship.
We have to go through it because otherwise we spend a lot of time in looking at the records in the first instance. Unless you look at it, you look into it.
Yes, Lord.
But you have many law officers for your department,
Lordship, but Mr. Pang is not available today, Lordship.
because unless you look at the records, we will be in fact spending a lot of time in looking at the original records and then finding out for ourselves.
Yes, Lord.
Be prepared, because otherwise in hearing in these matters, we'll be perfectly hearing. But we'll be putting questions, we'll be answering it. At least after a week. Both sides are represented, at least after weeks, so as to enable the government standing counsel for the FT matters to acquaint himself with the records of the tribunal. Because see, here there is a old land of prior to 60. And then the case of the petitioner is that he has inherited the land. But then you'll have to answer us from looking at this, why should that evidence be discarded? So if you don't look at the trial court records, you'll not be able to answer it. Correct? Go through it, because we find it very difficult.
Item 28.
Here also you have seen the records.
No, Lordship.
So then we adjourn it, because we don't want to do that exercise ourselves. We did some assistance. We go through it, we'll adjourn it. We go through the records, because whatever you have, we need your assistance, otherwise it's very difficult to
Lord.
examine the records and then answer the what do you call, decide the writ petition. All these matters,
Yeah,
any matter you are ready with the records, none.
no, Lord.
Then we adjourn all the matters. Same order in all the cases. Be prepared, because we're spending too much of time in going through the records ourselves. Or you can give us a declaration that will be much easier, that your lordship will rely on the submission of the petitioner, end of the matter. Because if you question it, then we need your assistance in responding to that. Yes, then there's a last matter for hearing, then all matters are adjourned. Let the government advocate did the record.
Lordship, here record in item number 31, there was no
Item
record,
32, there was a request to upgrade the matter.
Yes.
29, need to read a bit.
This case, notice was or answer on petition in custody, my lord.
Okay, there is item 29.
Sorry.
So writ appeal.
So, on a very short point, the Lord single judge has decided the whole issue on one point alone.
We find it a correct approach.
Very short point involved. The lordship will straight away come to para 7 of the judge.
Just a moment. So direction of section 27, rule 27.
Rule 27, the mandate is that it should be filed within 3 days. And what has been held is, it was received on 15th at 15/5/23.
Please give us a background because
The facts are, the other facts in fact would not even be necessary. Just to give a brief background.
no, because unless you give that, I
Yes.
will not be able to follow everything.
There was an election matter scheduled on 10th, on 10th of May. There were several anomalies in the voters list. Multiple representations were filed. They were not taken into consideration. In fact, the voters list itself was backdated. There were some people who were allowed to contest who were absolutely illegally included in the voters list. These were the allegations. And the whole issue pertains to the mechanism as envisaged in Rule 27. If your lordship will kindly have Rule 27 for a moment. Assam Cooperative Societies Election Rules 2019.
Because unless you give the background, you will not be able to travel.
Facts are only this much.
No. You will not be able to travel from foreigners to Panchayat.
I can. This has come before your lordship because my lord justice, UK and I cannot take it up.
No, that's okay, but you must.
It's a huge matter.
You must make us travel from there to here.
Foreigners to cooperative societies, it's a big.
Because there will be disparity. My brother will be able to catch, I will not.
I think my lord justice Chaudhary has had the occasion to deal with these matters for a long time in between.
That's why I said there will be disparity in the bench. My brother will catch faster than me.
Your lordship will have Rule 27 of the Cooperative Societies Election Rules 2019.
It's not there in this rules, na? Rules is not there in this book.
If this book is available, it is available.
No, we
In
not
fact,
have-
it is quoted in the judgment itself.
Okay.
If your lordship will kindly take up the judgment. Para 7,
We
it
have
is
not
quoted.
upgraded ourselves.
If your lordship will kindly turn to page 176, the relevant rule is quoted.
One,
Page 176. It's the later part of para 7, the rule is quoted. Have my lords got it. Page 176.
because we were thinking that with this order, you would give a walkover. No,
As I said, a very short point involved should not take more than 10 minutes.
yes, 27.
Redressal of dispute, sub-rule A. Any dispute relating to election of a cooperative society may be submitted within 3 days from the date of declaration of the results before the election authority. So this is the only provision that is relevant. And if your lordship peruses the next paragraph, that is what has been held by the learned single. A perusal of the above rule would show that any dispute relating to election of a cooperative society may be submitted within 3 days from the date of declaration of the results before the election authority. As already stated in the previous segment of the instant judgment, on 10/5/23 itself, the election results were declared as there were only 15 nominations against the 15 posts of directors in terms of 13A of the rules of 2019. Therefore, any shareholder aggrieved ought to have approached the election authority within 3 days from the date of declaration of the results.
However, from the annexure G to WPC number so and so, it is seen that the petitioners in both the writ petitions before this court submitted a joint representation which was received only at 11:40 a.m. on 15/5/23. This delay in submission of the dispute was in clear violation of Rule 27 of the Rules of 2019, and as such, the said representation filed by the petitioners herein could not have been taken into account. And based on that, the writ petitions have been dismissed. My lord, the factual situation is like this, my lord. 13th and 14th were second Saturday and Sunday. So naturally, in terms of the General Clauses Act, that has to be, that is the only point. So
No.
in my respectful submission, my lord, on this point,
That
and
will not help you because of the fact that you see in that clause, please read that. Please read that clause.
Oh, which clause?
General Clauses Act.
Yes, sir. Whereby any
Just a moment, let us also have a look. General Clauses Act. Is a
13th is
13th is second. In fact, my lord, I had.
goes in 2019. This is 2019, right? This is 2019.
2022.
23.
This is 23.
14,
23,
13 and 14.
13th is Saturday,
13th is
second Saturday.
second Saturday
So it will be off.
off.
14th is
14th
off.
is Sunday.
So
So
next is
therefore, the prescribed 3 days will be over on 15th. And
Yes.
since this was the point considered, the learned single judge did not enter into the merits of the case at all. So on this point, your lordship will perhaps may like to set it aside and remand it back for consideration on the merits of the case. This is the only point involved.
But there is another way of looking at it,
Or else if your lordship wants,
because that is the only.
that is the only point.
Okay.
May I please your lordship?
Yes.
Lordship, I am appearing for the caveat and respondent number 14, my lordship.
Yes.
Lordship, as per section rule 27, my lordship. This is termed as an election petition, my lordship, as per the cooperative societies act, my lordship. And my lordship, since this is a special act, my lordship, the provision of limitation act or the general clauses act, my lord, will not apply to this, my lordship. And on the basis of it, my lordship, I am to place one judgment of the Honorable Supreme Court. The right to the There are 3 of the lordship. Moreover, my lordship,
Give this citation so that Mr. Chaudhary would. know about it.
1985 3 SCC. Page number 590. There are 3, my lord.
Mr. Counsel, there is a different thing that whether section 5 of the act will be applicable.
Exactly, my lordship, because there
Whether if there is no power to condone delay, there is no power to condone delay. That's all.
yes, my lord.
Special act.
Because for that you travel to section 29, because that act is encompassing. If you
And
come to limitation act, section 29 is explanatory.
yes, my lordship. Moreover, my lordship, the judgment passed on my lordship 12/8/2024, my lordship, on read petition 3499, my lordship. There was an IA, my lordship, IA 3035, my lordship, 2024, my lordship. This IA has been disposed on that day, my lordship. That is not part of the
No,
records, my lordship.
where is the observation on in this decision?
My lord.
Where is the observation on General Clauses Act?
My lordship, it is not there, my lordship. It is only on the
It's
basis
not
of the
there.
limit.
Because that's why
That is section 5.
My lord, section 5, my lordship.
you are aware of
My
section
lordship.
29. Have you read that section of Limitation Act?
29.
You have not. Because it says that whenever there is a special act, the limitation prescribed therein shall prevail. But that excludes section 5 application. And you don't have to go to even Supreme Court. I think we both have authored orders on that.
My lord, my lord.
So this is something.
So, my lordship, this
we are acquainted.
IA is not part of the record, my lordship. And moreover, my lordship, membership is the only issue, my lordship. They had the occasion, my lordship.
No, we are only one issue because we are issuing, we are intra-court appeal.
Yes, my lord.
The only point is that date of 10/5/2023
Yes, my lordship.
and 15/5/2019, we are not entering into the merit. Because then you lose an forum. You take a risk of losing a forum. Because once we decide, then we decide.
then I have to check some judgment, my lordship, whether general clauses apply on this or not, my lordship.
Oh, you don't need to any judgment. We are aware of that. That's why we asked you this question. Is there something on General Clauses Act? You have read General Clauses Act. It has omnibus application everywhere. It can come into every field. It's a general clauses. It's a dictionary for law.
Although, my lordship, these pleadings were not taken before the single judge, my lordship. This one. That holiday, my lordship, was not taken, my lordship. So it's just to check with the official respondents, my lordship, it was holiday or not holiday, working or not working, my lordship.
Okay, we look at the video of that day and then decide the matter. It's, you see, a question of law is whether you plead or don't plead, or you argue or don't argue.
My lord.
Now, you tell us one thing. Now, you file a writ petition. And we say that because of this law, the writ petition is not maintainable. And dismiss the writ petition. So if you go to a higher forum or in the intra-court appeal, will be it a good ground that I did not argue that matter. The court found out a law and then dismissed it. Is that a defense? Because then before addressing every court, you'll have to tell us that here, please don't apply anything from your own knowledge of law. Don't ask questions. It'll just be like jury trial, which is abolished, where the judge does not put any incriminating questions. It is the jury who gives the response. You do know about jury trial. Judges don't have the discretion of anything. The good question is that it's a question of law. If 3 days was applicable, and Saturday, Sunday is demonstrated this second Saturday and Sunday, in that event, what is your response? To that query, what is your response? That time you did not argue, but now we are putting you a question. In this regard, what is your response?
My lordship, as per 27, my lordship, within 3 days, my lordship, they had the time to file, my lordship, within 3 days, my lordship.
Okay.
Because on 10, the election is declared, my lordship, 10 itself, then 11, then 12, my lordship, then 13, 14, my lordship.
Okay.
So they had the time, my lordship, to file this
Then we,
election petition because they knows it, my lordship.
no, that's
Because
okay.
they are litigants, my lord, they knows it because within 3 days they have to file, my lordship.
My learned friend is asking your lordship to exclude the third day.
Second Saturday, registrar was sitting in his office.
No, my lord. I'm not saying so, my lordship. I'm saying since counting should be from 10, my lordship.
Election, who is the election authority?
The register, my lordship.
Second Saturday, he was sitting in his office. On 13th?
No, my lordship. I'm saying on 10, my lordship. 10 was not Saturday.
No, 3 days time. Third day will fall, I think, on 13th or on 12th.
30 one day will be excluded. General Clauses Act.
Mondays will be excluded.
But yes, what is your response? Because we have asked you a question.
My lord,
My brother,
my lord,
will
can
ask
fix
you a
the matter
question.
for hearing, my lordship. I'll come prepared.
We are hearing it.
My lordship, I'm not prepared, my lordship, because
Oh, no, that is not a good reason. We don't need your preparation. We think the law is giving the answer. Who has asked you to be in court without preparation? And at least in this courtroom, you can ask anyone. Anyone, you just turn around and ask anyone. There's a thumb rule in this bench that I am ready for hearing. We are both ready for hearing in the motion stage, admission stage, order stage and hearing stage. Unless you are the bar, you take a resolution that matters should not be heard in motion, admission, order stage. Take a resolution and throw it on our face. No hearing at motion stage. No hearing at, no disposal at the admission stage. We'll be very happy. Because I ask you to be here. You file a caveat. When you file a caveat, you are ready with the hearing. Do you think filing of caveat is an empty formality? You put in sufficient years of practice. Tell us why a caveat is filed. To oppose the admission, oppose an interim order. Can you come up and say that I filed a caveat, I am not ready? Don't expose that you are worthless. Pushing us to a corner, you're asking a question. It's a question of law. Now, if the registrar is not there, there is only one thing which can remain, which is a very good old English saying, walls have ears. So you expect that when I am not there in the courtroom, you will go to my courtroom's walls, whisper something, and when I come on Monday morning, the walls had ears, so it will tell me that lawyer so-and-so came, whispered something in the walls. This is what he has said. It's an absurd proposition you are arguing. Even without arguing, you are saying so many things. And you know, in the return, Mr. Chaudhary, what is happening? In return, you know what is happening actually. Huh?
I can.
Bar comes back and says that you are no longer that who were you earlier. Now you have become too horrible.
They would not use that word at least.
Huh?
They would not dare to use that word, but I can appreciate what is coming from you.
Questions become uncomfortable, therefore what you can do? You can just go out in the corridor and say that he is a worse judge now. Is it not?
One of the stalwarts in Supreme Court once said that is a lawyer's favorite pastime, criticizing.
You see, my brother asked you a question.
Madam, I'm sorry, my lord.
If the order is on 10th, if the event election happened on 10th, according to you, what is the third day? It is 10th, 11th, 12th,
13,
or it is 11th, 12th, 13th.
13, my.
13th. So 13th would be Sunday. Second Saturday.
Second Saturday.
Okay, you are passing the order. Adjournment is out of question. Heard.
One last opportunity may be given, my lordship. Tomorrow maybe, my lord. I may be prepared, my lord.
No.
I'm sorry.
Tomorrow is second Saturday.
Tomorrow is again second Saturday.
I'm sorry, my lord. Second
Not
Saturday.
third.
Sorry.
Not working day.
Non-working day. No, that's not the end of the matter.
Next Monday, my lordship.
You take an adjournment, you take it to the first day.
Saturday seems to be my learned friend's favorite day. Man.
You see, you before we start, you take an adjournment. We never mind. But having heard it,
I'm extremely sorry, my lord.
spend-
Maybe
spending
on Monday,
so
my
much
lord.
time, no, we can't help it.
I'm extremely sorry, my lord.
You see, you see, I don't know whether you have heard of him or not. He was a very good lawyer. Very remarkable name. I did not meet him. but his name was Kalimuddin. There are many stories of Mr. Kalimuddin. You have heard, I suppose, of him. One of the most respected names when it comes to the use of wit in court. So the gentleman who told me was again a very, very renowned lawyer. Of earlier times, he is no longer there. He told me that once he heard Mr. Kalimuddin explaining to the clients outside when the case was lost. He said that, well, today you have earned a right to appeal, which the other side has lost. So you give that opportunity.
My lord, I'm
You
extremely
win a
sorry, my
right.
lordship.
You win a right. No, we don't adjourn it. After hearing matters, we don't adjourn it.
My lordship, maybe on Monday, my lordship.
Mr. I. Chaudhary, learned senior counsel, assisted by Mr. J.M. You are assisting or Mr. Vitti? Mr. A.V.T. Hawk, learned counsel for the petitioner. Also heard. For Corporation Department, who's there? You're there. What's your name?
NZ Azad. NZ Azad. On behalf of
Oh, yes, we did not hear you. Anything you have to say?
actually, lots of my senior is out of station.
You should have taken adjournment earlier. After we make up our mind, then. But Mr.
NZ Azad.
MZ Ahmed.
NZ Azad. NZ Azad.
MZ
Azad.
Azad.
And
AZAD.
Yeah.
NZ Azad. Learned
Behalf of G. Bartole.
counsel appearing on behalf of Mr.
G. Bartole. G. Bartole.
G. Bodle and standing counsel for the Corporation Department representing respondent numbers 1 to 4. And also Mr. R.M. Mazumdar,
D. Hussain, my
D. Hussain. Mr. D. Hussain, learned counsel appearing on behalf of the respondent numbers. You're from 7 to
My lordship, I'm only for appearing for 14, my lord.
only for 14.
Yes, ma'am.
For respondent number 14.
On the last occasion, I distinctly remember my learned friend saying that he is appearing for all the private respondents.
Yes, that's what we reported.
Your lordship peruses the order dated 7/11/24.
But caveat, but we remember he's saying this is only one.
Lord, one last opportunity be granted, my lord. I'm extremely sorry, my lord.
Just a moment.
Oh. Not the door, 1 to 20.
You say,
Counting place for the origin from the date of election to
then you say Mr. I. Chaudhary and counsel assisted by Mr. A.V.T. Hawk, counsel for the petitioner. Next para. Mr. NZ Azad Leonard, standing counsel for the Corporation Department, as well as Mr. D.
Hussain, my lord.
Hussain, learned counsel for the respondent number. Respondent number 22.
14, my lord.
It's a 14. Respondent number 14. No. You please decide for whom you are appearing.
Oh, my lord, I'm sorry, my lord, 13, my lordship.
13. It's probably
Short of
13.
dash one.
Okay, give it a wait for adjournment. Next one. The learned senior counsel for the appellant has submitted that the elections of the executive committee of Gandhigram Samabai SAMA BAI Samiti Limited was held on 10/5/2023 in the AGM call for the purpose it is projected that there was several anomalies in the manner in which the elections were conducted, including preparation of the voters list. And therefore, the respondent number 13 was the writ petitioner.
Not only
From the date of.
Shall approach this court by filing
Same just that.
writ petition under article appellant. File the petition. Approach this court by filing WPC 3499 of 2023. However, it said writ petition was
There were two writ petitions. I had filed one, and there was another filed by Haripada Das, that is 2817 of 23.
okay. Said petition dismissed by a common order. By common judgment and order dated 12/8/2024, passed in WPC 2817 of 2023 dash Haripada HARIPADA Das was the state of Assam and others, and WPC 3499 of 2023 dash Shambhu SAM BHU Vaishnav BAI SHNAB versus state of Assam and others. Full stop. Next paragraph. The learned senior counsel for the appellant has submitted that under the Assam Cooperative Society rules,
13 is
Election rules.
within bracket election, it's within bracket.
Yes.
Election, election, that was rules.
29.
2019.
2019.
2019. It is provided that section rule 27, under rule 27, it is provided that it's provided under clause A thereof that any dispute relating to election of a cooperative society may be submitted within 3 days from the date of declaration of the results, before the election authority. Page 176. Full stop. It is submitted that in this case, the elections was held in the AGM held on 10/5/2017.
2023.
Oh, sorry, 23, but the intervening dates of 13/5/2023 was a Saturday and 14/5/2023 was a Sunday. Second Saturday, Sunday. And therefore the representation against the election was submitted before the Registrar of Cooperative Societies. It's a representation.
No.
With the Cooperative Society on 15/5/2019. Full stop. Taking recourse to the provisions of the General Clauses Act, comma,
Section 10.
1897, comma, they submitted that the submission of representation on 15/5/2019 could not have been held to be beyond the time prescribed under Rule 27 within bracket small a of the Assam Cooperative Societies election rules. Next paragraph. The as stated here before, the learned standing counsel for the Corporation Department as well as the learned counsel for respondent number 13 both made a prayer for adjournment. Next paragraph. Accordingly, letter notice returnable in 4 weeks be issued. Post round. The instructing counsel for the appellant shall serve requisite extra copies of the writ petition of this writ appeal to the learned standing counsel for the respondent numbers 1 to 4 within 2 working days. Full stop. The appellant shall take steps within 3 working days for service of notice on the respondent numbers 5 to 12 and 14 to 23. The learned instructing counsel for the appellant is at liberty to collect the postal receipt number and submit postal track report prior to the next date of listing. Next paragraph. Heard both sides on the prayer for interim relief. Full stop. On the prayer for interim relief also, from the learned standing counsel for the Corporation Department as the learned counsel appearing on behalf of the learned standing counsel for the Corporation Department as well as the learned counsel for respondent number 13 has prayed for adjournment. Next paragraph. The issue as to whether the representation against the election submitted on 15/5/2023 was beyond 3 days is a question of law. Full stop. Next paragraph. The 13 full stop. Moreover, it is not in dispute that the learned single judge had dismissed the representation only on the sole ground that the representation submitted on 15/5/2023 was beyond prescribed 3 days, as the elections were held on 10/5/2023. Next paragraph. From the provisions of section 9 of the General Clauses Act, 1887, 1897, the first the first in the series of days or any other period of time we just say section 9 of the General Clauses Act, it just follows. Full stop. Therefore, on application of provision of law, the first in the series of days from 10/5/2023 is required to be excluded. Full stop. Next, the provision of section 10 of the General Clauses Act is quoted below. Next, from the above, it is observed that under subsection 1 of section 10, if the office is closed on the last day of the prescribed period, the act or proceedings is required to be considered as done or taken in due time if it is done on the next day afterwards on which the office is open. Full stop. It is not the Learned Counsel for the respondent number 13/Creator has not been able to demonstrate that second Saturday and Sunday being 13/5/2023 and 14/5/2023 were declared as working days for the Registrar of Cooperative Society, ASAP. Therefore, we find that the application that the appellant has been able to make out a prima facie case that the representation submitted on 15/5/2019 would be within the meaning of within the scope of section 9 and 10 of the General Clauses Act, 1897. Full stop. They said next paragraph. They said issues as raised by the learned senior counsel for the appellant requires examination. Next paragraph. Nonetheless, as as the appellant has been able to make out a prima facie case for hearing, the court is of the considered opinion that the balance of convenience would be in favor of the appellant and against the respondents for granting identity relief as prayed for. Full stop. Moreover, comma, in the event the interim order as prayed for is not granted, comma, there is likelihood that the prejudice that is suffered by the appellants would be more comparatively to the prejudice that could be suffered by the respondents. Full stop. Next paragraph, such circumstances, comma, the operation of the order dated 29/5/2023 issued by the registrar of, who is respondent number 3? Assistant registrar.
Assistant registrar.
Oh, I'm sorry, there's something wrong. 35. Okay, what is it going to stay the operation of the impugned judgment on order dated 12/8/2024 passed by the single judge in WBC 3499 of 2023. Full stop. Full stop. Resultantly, comma, the functioning of the board of, what is it called? Board of Directors.
Board of Directors.
Board of Directors of Gandhigram Samavay Samiti Limited, Karimganj, pursuant to election held on 10/5/2023 is also stayed. Next paragraph. The competent authority leading the, who will make the one-man committee?
Registrar.
The registrar of the registrar of Cooperative Society of Assam shall do the needful to have a one-man committee appointed. Do the needful for functioning of the said cooperative society in accordance with the provisions of the Assam Cooperative Societies Act, 2007. Next, but list after 4 weeks on a date to be fixed by the registry.
Deeply obliged.
My lord, I've last submission, my lordship. This general clauses section 9 and 10, my lordship, may not be applicable in election petition, my lordship.
No, you either take an adjournment or you argue the matter.
Well, I'm saying,
You
my
can't do
lordship.
two things.
Are you representing all?
No, my lordship, I'm paying 13, my lordship.
No, you
Reserve your.
reserve your argument. We gave you an opportunity. You
My
take
lordship,
an
because of the
adjournment.
public property society will suffer, my lordship.
How let them suffer?
In election.
Unless people suffer, they won't come to
Because
court.
my lordship is a low point, my lordship. All of a sudden
No.
come out, my lordship.
This
I'm
is-
so sorry, my lordship.
You've seen the advertisement of Surf Excel.
Yes, my lordship.
Dag अच्छे है. See, if somebody suffers, they will come to you.
Yes, my lordship.
If not to you, to your brothers.
I'm so sorry, my lordship, to bother me.
No,
my
you
lordship.
either pray, you either do the better or you pay for an adjournment. You can't do in between. You can't sail in two boats.
My lordship, because all of a sudden this law point has come out, my lordship, the general clauses,
No,
like my lordship.
we start hearing. If it has dawned on you, question of law has dawned upon you, you do the hearing.
It's a specific ground we have taken.
You do the hearing. You can't ride on two
Highly
boats.
obliged, my lordship.
You can't ride on two boats. When already there are two, what do you call? When only two heads are here, you can't ride on two boats, and the head is in one boat.
Item 31.
Record is not there.
The previous order, there was observation for consideration of the interim of the lordship.
For bail.
Lordship.
What is the point here? Why we were dissatisfied? I forgot.
Actually, my humble submission was that on the
Oh, ex parte.
yes, expert order.
We are not satisfied with your explanation for the delay.
My humble submission was that the financial hardship was the main ground lordship. And this was proceeded and decided in the peak COVID period lordship.
Huh?
During the peak COVID period, the case was proceeded and decided lordship. And subsequently, I
18
did
to
not
21.
lordship.
How can we give him an interim election then?
Lordship,
COVID period was there.
yes, Lordship
That is,
case 42 Lordship order reflects that a Lordship proceeded accept the notice and appeared to his.
it's the
immediate
COVID period.
position.
We get we see leave even by that Supreme Court judgment.
After COVID period.
That is also a COVID period.
That was COVID period Lordship, but after that Lordship, after a gap of long years, Lordship 2 years, he appeared before.
Last
Lordship
time he
may,
did not give.
yes, Lordship may.
That is due to financial hardship lordship. I have explained
This
in.
COVID period, she gets her advantage. Okay.
After her arrest, Lordship, he approached before this honorable court Lordship. She is very much aware about the proceeding Lordship.
Hmm?
She is very much aware about the proceeding, and after her arrest,
She's not
she
taking a
approached
ground
before
that her
this
husband had
honorable-
died. Husband had died. When did the husband die?
Within that period lordship.
COVID period.
Yes.
Heard Mr. M.I. Hussain done it for the petitioner. Also heard Mr. G. Sharma done a standing counsel for the FT matters representing respondent number 2, 5, and 2, 6, and 7. Mr. And Mr. R. Talukdar, learned government advocate appearing for respondent number 5. And Miss S. T. I just forget his name, I don't know why. S.T. Khan, learned counsel appearing on behalf of Mr. E.I. Ali. Oh, sorry, Ms. P. Barwa, learned standing counsel for the respondent of 3. So there is no representation from respondent number 1 and 4. Next. By order dated 11/11/2024, court has had called for the relevant records from the valid tribunal. This record is not yet received. Next. The learned counsel for the petitioner has prayed for bail. That she is apprehending arrest in connection with ex parte opinion dated 18/2/2021, passed by the learned member from Foreigners Tribunal Roman 3, Barpeta, in FT case number 28 within bracket Roman 3 of 2019. This you will find in page 42, case number, by which the petitioner was declared to be an illegal migrant. Next point. to explain the cause of non-appearance before the learned tribunal and to explain the delay. Carrying this opinion of the learned counsel for the petitioner submitted that the proceedings was taken up by the learned foreigners tribunal dash Roman 3 Barpeta during the peak COVID period. And it is during that period that the husband of the petitioner had also expired. So it is proceeded due to financial hardship. The petitioner could not challenge the said order within reasonable time. So it is also submitted that the petitioner has sufficient documents to show that she is not a foreigner but a citizen of India. Next paragraph. Does it perhaps it appears that the notice of the proceedings before the learned foreigners tribunal was served on the petitioner, but and she had initially appeared along with her engaged counsel on 24 to 2020. But since then she could not appear. And that it also privacy appears that the said period was during the COVID period. You have given the date of death of your husband? No. Huh?
I'm not providing.
Not provided. Okay. Next paragraph. The period for bail is opposed by the learned standing counsel for the FT matters on the ground that delay is not properly explained and the subsequent delay from the date of the opinion till the present writ petition was filed on 21/10/2024 is also vague and without any material particulars. Next paragraph. Be that as it may, having noted that the petitioner has been declared taking note of the fact that the impugned opinion was rendered during the COVID period and taking note of her reasons for delay in having this writ petition. And the court is of the constituted opinion that while the issue of delay latches should be kept open for decision in the writ petition, and petition be given, the petition be allowed to approach the jurisdiction to approach the superintendent of police within Packet border of Barpeta within 10 days from the date of the order, and on furnishing a bail bond of ₹5,000 with all those conditions. Let's make clear that if the petitioner does not appear before the said authority within the time allowed, the order of bail shall stand lapsed by a flux of time. Next paragraph. Did the receipt of the trial, the records of the travel be awaited? At least after 2 weeks. Just after 2 weeks. Obliged.
Item 32.
Maybe not. Well, in this case, man, notice was issued also call for an interim will consider on the after receival petition in custody, my lord. And
He's in custody.
yes, my lord, from
Perhaps we did not find anything in the matter. That's why we did not give bail.
my lord, actually, my lord, the fact is that, my lord, the order was passed long, my lord. So you lost it on that day, my lord, you are left some time.
Not
So,
in trial.
in-
You were
in-
arrested when?
My lord,
When were you arrested?
my lord, 2nd September 2004, my lord.
2nd September,
Yes, my lord.
3 months.
Near about 3 months, my lord.
Okay. 3 months we are giving you, okay. Third, Mr. H. Adil, and counsel for the petitioner. Also, Mr. H. Kuli, learned counsel appearing on behalf of Mr. A. Adis, learned standing counsel for respondent number 2, and Mr. G. Sharma, learned standing counsel for the FT Matters and Home Affairs, representing respondent number 3 and 6. And Mr. R. Taluga, learned government advocate, appearing for respondent number 5. So there is no representation from respondent number 1 and 4. Next paragraph. The courts just called from the
516
from the learned tribunal
নারায়ণ
policy.
হল মারিয়ে দিলে আপনাদের রিসিভ করে দিন বলে করছে
Next paragraph, learned counsel for the petitioner has paid for bail, which is opposed by the learned standing counsel for the FT matters. On the ground that there is a substantial delay on part of the petitioner to challenge the opinion dated 8/9/2019. That the causes assigned for the delay is not sufficient. Be that as it may, take note of the fact that the petitioner has been arrested and taken into custody on
22nd September,
on
2/9/2024.
22/9/2024.
2, my lord.
29/2.
2/9/2024.
2/9. It's a
Yes.
02. It's actually 2/9/2024. 4. And was in custody for almost 3 months. So 9, there's 10, 11, 2 months.
No, 80 days, my lord.
Court is of the consideration that the petitioner may be granted bail. So accordingly, it is provided that the petitioner shall appear before the Superintendent of Police within bracket border, Bogota, within 10 days, same order, bail. So, oh no, this will be different.
8 PM.
Will appear before the Superintendent of Border, border, don't give time, border, and shall furnish a bail bond of rupees 5,000. No, not the petitioner, the family members of the petitioner. Family members of the petitioner shall always furnish. And thereupon, within 3 days, the Superintendent of Police of Bogota shall take steps for release of the petitioner from the
Matia, my lord.
transit camp for Matia Gwalpara. And she would be brought to the office of the Superintendent of Police, Border Bogota. And the said authority shall the iris of the eyes, shall capture the iris of the eyes as well as photographs, fingerprints. So those undertaking. And thereafter, petitioner shall be released on bail. Within 3 days, question, no? Within 3 days from the receipt of certified copy of the order, it accepts. Okay, hello.
LCR is already here, Lordship. LCR is already here.
It is there. Okay, the LCR is received. Not received, question, received. Okay, list in the, list the matter in the admission column. Huh? Not list the matter after 2 weeks. Hello, okay. That's it. Recapitulate. Hello, sir. Mr. Sharma, go through the records. It will be easier for us.
Lordship.
When we see many things come to our notice,
Yes, Lord.
it's better that you look into it. Otherwise, we end up asking questions.
Lord.
Time being item 18.
May I please, Lord?
Yes.
Yes, my lord, a expertly order, my lord. Passed on, my lord, 17/3/2023, my lord. FP Borbita #1, my lord. In this case, my lord, the initial.
Your
my
name
lord,
suggests that you are a foreigner.
my lord,
Your name itself suggests that you are a foreigner.
my lord, there's a interesting, they say, Mohammed Ingraz Khan.
Once
That's
once your name suggests so, why should we?
But my lord, but fortunately, my lord, he was born in the soil of his motherland, India, my lord. In the year of 1952, my lord, he was born.
No, why would an
And-
Indian keep a foreign name?
What my lord? It was given by my
If
lord.
he considers this country as the mother, I will not keep a name like that.
Actually, his father was a businessman, my lord. He was supplying the, my lord, jot at the Parghat, my lord, at the bank of river Brahmaputra, my lord, this Bohori area, my lord. And that time, my lord, there was some transaction with them, my lord, some British businessman, my lord. I have also asked him.
But why?
My lord?
But you were served with a notice.
Yes, my lord.
Then why you did
And
not
there-
appear?
Thereafter, my lord, on 2 or 3 occasions, my lord, which I have took time, my lord. Let's say I could not file WS, and accordingly that time was allowed, my lord. But in the meantime, my lord, thereafter, my lord, he fell on illness. Thereafter, my lord,
There's
after
nothing is very convincing.
my lord,
There's no
after
description of
getting, my
nothing.
lord, little bit recovery, my lord, he, my lord, aged about, my lord, 71 years, my lord, and there was no one to look after him. Very aged person, my lord. That's suffering from various ailments, my lord.
You're not supporting, not supporting documents to show that he is ill.
Yes, my no source of income, my lord. Then he, my lord,
We issue notice, let the records come, then we consider your deal. But there's no explanation at all.
my lord, I have explained, my lord, in para, my lord.
Too vague. Illness, we don't know what type of illness.
My lord, is of
I have an illness
As
of
of
asking questions.
ailing person, my lord.
I have an illness of asking questions. That is also an illness. What can be done? We are not satisfied, Mr.
My
Ahmed.
lord, he is, my lord,
Let the
left
records come.
the state of Assam, my lord, and used to stay at, my lord,
Let the
UP,
records
my
come.
lord,
We are
at
not
Lucknow.
satisfied with the explanation. Explanation, there is nothing.
At page, my lord, page 9, my lord, para 10, my lord. I have stated, my lord. Para 10, my lord, page 9. Only, my lord, he could not appear, my lord, on, my lord, on 2 occasions, my lord. It was not long pending case, my lord. Immediately after receipt of, my lord, notice, my lord, he has appeared, my lord, on bona fide manner, my lord.
and thereafter, my lord, cooperated, my lord, on 2 or 3 occasions, my lord. 3 occasions. Can you see the order, my lord, at page at page 20, my lord. At first, my
See,
lord,
there's no explanation at all. You say that you were not aware of the dates. Who would make you aware?
my lord, after little bit recovery, my lord, he has he went to, my lord, Uttar Pradesh, and there, my lord, he collected some scrapped materials, my lord, and he used to sell them, my lord, just to for his livelihood, my lord, and there was no one to look after him, my lord. Very age-old person, my lord.
Those things don't. You see, once you say that you are ill, then you go to Uttar Pradesh, sell scrap.
No, my lord. Then my lord, his wife, my lord, taken him, my lord.
You don't
That's
know.
what-
Your wife
Only-
can take
only
him to
2
Uttar
occasions, my
Pradesh.
lord,
Why
then-
can't be taken to? Why there's no one to take care of him
And
when he was
thereafter,
ill?
my lord, after coming to know, my lord, the case,
No,
my
no.
lord, thereafter he
Not-
came,
not
my
a
lord,
case
and
of
on
bail
bona
immediate-
fide manner, my lord, he is now
Not a case of
willing
bail
to, my lord,
immediately.
cooperate, my lord, regularly cooperate, my lord.
Not a case of immediate bail.
And only, my lord,
You were taken
occasions, my
arrested
lord.
when?
He was not, my lord, absconding, my
You
lord.
were arrested when?
Not arrested, my lord. So, after
then-
coming to learn, my lord, that's it,
No, no.
yes, my lord.
No.
This immediately came, my lord, and filed this
You
petition, my
listen
lord.
once. No, no.
And-
Mr. S. Ahmed, learned counsel for the petitioner. Also heard Mr. G. Sharma, learned standing counsel for the FT matters on home affairs, representing respondent number 2 and 6. And Mr. H. Cooley, learned counsel appearing on behalf of Mr. A. Ali, standing counsel for respondent number 3. And Mr. R. Taluga, and a government advocate appearing for respondent number 5. By filing this representation under Article 226 of the Constitution of India, what the petitioner has said, the ex parte opinion dated 17/3/2023, passed by the learned member of Ordinance Tribunal number 1 of Borpeta in FT case number 900/2018. It's page 27. Comment by which he was declared to be a foreigner of post 25/3/1971. Issue notice. Returnable on 17/12/2024. Requisite extra copies of the writ petition be served on the learned CGC, State and Department Council within 2 working days. Prayer for bail shall be considered on receipt of the records. However, it is provided that in the event the petitioner is apprehended, he shall not be deported without the order of the court.
Obliged, my lord.
Time being item 1.
Lordship, that record is not available in the concerned SP office, Lordship. Only that part was recorded in their diary, Lordship, that project.
Record here, what is this?
Says
It's a records of 2001 ERO case
yes, Lordship.
by IMDT.
Yes, yes.
Not found.
Not found, Lordship. Only that much only recorded in their diary, Lordship. Then Neshitu Das was declared as Indian citizen, Lordship.
Not available.
Not available.
But it has to be tracked. Because this IMDT was disbanded.
Yes,
After
Lordship.
this record will come somewhere.
Lordship, I have telephonically I talked with the concerned SP Lordship, and there was some shifting was happening Lordship in,
No, but then it has to be recorded.
then Lordship,
Has
some
to-
written instruction Lordship.
Take reasons.
uh,
Okay.
To answer this.
Both sides are represented.
Certificate.
So G Sharma, the standing counsel for the FT matters, representing respondent number 3 and 6. Has submitted that pursuant to the order dated 6/11/2024. No, sorry, make it 30/10/2024 and 6/11/2024. He has telephonically conveyed the his telephonic spoken to the concerned superintendent of police within Brigade border,
Goalpara.
Gwalpara, who has orally submitted that the records are not readily available and that in the register, it is only mentioned that the petitioner has been declared as a
Petitioner, not petitioner, brother of the petitioner. Lordship.
Huh?
Brother of the
the-
petitioner.
the-
This is
the
brother's case.
petitioner,
Lordship.
namely, what is the name?
C2 does.
Huh?
C2 does.
Spelling, what is it? Spelling?
SITU, Lordship.
SIT, C2 Das. Was
Declared Indian by IMD
declared Indian by
Tribunal
the
in
illegal
7/10,
migrants
2022.
within bracket determination, bracket close tribunal by opinion dated 7/10/2002. He prays for some more time to obtain written instructions to that effect. So that in the meantime, the authorities may also try to track the said records, trace out the said records. So accordingly, matters since adjourned today. List on. This after 2 weeks. Give a date after 2 weeks. This after 2 weeks. Give a date, huh? After 2 weeks. This was also. Prepared for. Bail shall be considered on the next date. Oh, there is already an order. You are already protected. Shall not be detained. Okay, not required then. Okay. This after 2 weeks. He's already given bail.
Yes, Lord.
Not to be arrested.
How wouldn't this object?
No, then not required. Let it be. He is already protected after 2 weeks. On a date to be fixed by the registry. Tree. Oh, 4 orders. There's no representation from any of the sides. So as per the office note dated 21/11/2024, no amended cause title has been filed by the appellant. Full stop. Next paragraph, if the network is not done within 3 working days, adverse consequences may follow. Next paragraph, list. After a week.
Item 34 for hearing.
Yes, this is review petition.
Your lordship,
I hope you are aware of the limitations in review.
yes, your lordship. Your lordship, on last occasion, your lordship had already verbally directed to submit some genuine documents to establish linkage with the father of the petitioner. I sought instruction from the petitioner. The petitioner had told me that he had some school documents in his home, but the petitioner has been ill for some times for last month, and now he's admitted to the Borpeta Medical College. There's today he is admitted to Borpeta Medical College, and there are some of his medical documents. He has been suffering from chronic cystitis. Some urinary tract related infections, painful bladder disorder, I think.
Both sides are represented on the prayer made by learned counsel for the petitioner. The matter is adjourned today. This after 2 weeks on a date to be fixed by the registry. Be prepared because review we can't prolong it longer.
Yes, your lordship. Once he able to come and submit the documents,
No, don't wait for that. We may not wait. We are getting advantage because we don't want to discourage young lawyers who are there. But this can't be extended for long.